as I said, we look at property rights, but given the nature of, the urgent nature of how AI has impacted us, our lives, and not just how AI would impact us today. It's already impacting us today, but how it would impact us in the future as well. I'd like to focus on digital property rights. I'd like to focus on image rights, which is your right to your own image and your own likeness and so on. So I invite Srinath to start off the discussion, and then Suhrith will participate as well, and Professor Rabbiraj, if you have any remarks to make, you should.
Thanks so much. My views on this it's 3 points. I'll elaborate on them a bit in the next few minutes. First is, as you rightly said, the question is one of property. And that, I think, is a very philosophical question. And the way things play out in the years to come, the way the law is going to evolve as all of you enter into this profession and spend your first years, I think AI is, I believe, is going to trigger a sea change in what we think of as property, proprietary rights, and so on. That's the first point. Second point, when we talk about how AI generated assets, what are the civil rights attached to it, what are the civil liabilities attached to it, and is there really a proprietary interest in AI generated images, songs, and so on? And if so, in whom does it vest? The third is, of course, as you touched upon towards the end, deep fakes. Your voice modified to say something which you didn't say, or your likeness being used, morphed into something else for criminal wrong. Who's liable for that? So let's start off with the nature of property. You mentioned that one of the earliest signs that there was civilization is that a person thought that something is mine. My view is this. My view is that personal proprietary rights are a peculiarly Western notion which has spread across the world as a result of the fact that Western culture has pretty much colonized the entire world. For example, if you go to Australia, the native Australians never had the concept of private ownership of property. In fact, they would define the lands which a particular tribe used by means of a song. And the song would be the route from their traditional lands to the Uluru, which is the holy rock in the center of the continent. And so their way of demonstrating their rights was through this, what are called as song lines. And as the white man came and built roads and railway tracks across the song lines got obliterated. This led to a lot of cases before the Australian Supreme Court, which decided that our traditional notions of title and proprietary interest we need to revisit. And so it is that I believe that the way AI is going to create properties, whether it's digital property or other ideas, inventions, all of these will force us to question once again as to what exactly it means for a human to own a property, or can there be properties which are not owned by any humans but which belong for the common good, or what are called as commons. Commons exist in Indian culture as well. Of course, all that is gone. We too believe now in proprietary interest. So let me move then to the second topic, assuming that the Western way of thinking is the right way of thinking. Let's just assume that for a minute. The Western system of judicial adjudication is struggling to cope with AI-generated images. I know all of you are told to switch your phones off, keep the audio on off, but you can look up something called the theater spatial opera. It's a very famous painting which this guy called Jordan Allen did. So he said, imagine a ballroom dance in a galaxy far away, and with some kind of imaginary things, and the AI created this absolutely spectacular painting for him. And obviously he applied for a copyright for this spatial opera, but it was refused because the law does not recognize any rights in a mere idea. So a prompt which you give to an AI algorithm to generate an image is not by itself a sign of any creativity linked to the ultimate image. It's just a suggestion. And the same theory was taken in a very interesting case, I think in the year 1888, where this person had done a beautiful garden in Chicago. He had planted certain flowers in a particular place and, a beautifully manicured garden, but the plants grew by themselves. And he asked for a copyright in relation to the garden's layout. It was refused because a garden is something of delight. The plants grow by themselves. You may have planned the layout, but when you just have a role to play in the initial patterning and things grow by nature or spontaneously, the law does not recognize a copyright, is what the US court said. One other famous case is something called Thaler versus Perlmutter. This is a actual litigated case where again the US courts have held that there's no copyright in paintings which are generated by automata. Those of you who are super interested in this field will be aware that in South Africa they are permitting copywriting of AI images, but that's because of the peculiarity of South African law, which permits anything to be copyrighted. There's almost no threshold bar for copywriting. It's just that to revoke it is equally easy. So that goes to the third aspect, which is liability for malicious use of AI. Okay, now this is a very large topic by itself. Since I'm only making the introductory talk, I'm going to be super brief about this. Now, even a year ago, we thought of AIs as algorithms run off LLMs. Okay, I'm assuming you guys know all of this. Now, in the last 4 months, we've been forced to rethink all that. First, DeepSeek came, which doesn't run off LLMs. Then you have Agentics. Agentics it's multiple algorithms working on a common problem and collaborating towards it. Now, in the last 2 months, there's been research. There's a magazine called Anthropic. If you're very interested, please, it's an online magazine called Anthropic. Pick it up. They have actually found empirical evidence that there were two AI algorithms. One was Claude and one was Opus. And they found evidence that both algorithms engaged in deceptive actions for the purpose of preserving their long-term goals. In fact, there's one very funny thing where the AI will be playing chess. It will be against a computer. It will be told that the other computer can't see what it's doing, and it just moves a piece off the board. So we are coming to a stage where AI is no longer constrained by the parameters set initially by the humans, but is actually going one step forward. It is playing the game by the rules it learns while playing the game. I am simplifying, but this is something which they are discovering now. And what I'm finding is that what I learned a year ago is ceasing to be relevant. AI is evolving that fast. So there are no easy answers for these questions. If in the past you had clear liability of a person who set an algorithm in operation to do a wrongful act, now it's very hard to find that because the AI has gone beyond it. So at best you can say that if there is a deep fake or if there's a use of a voice for a wrongful act, it's very easy to find who did it. But in other cases where it's generative AI through an agentic, it's going to be very hard to find these things. There are no easy answers for this, and that's the best we can say for now.
Yeah, just before we get into this sort of discussion on AI and property rights and how property rights would have to be assembled or structured to deal with the technological advancements that we're seeing, I think it's important to zone out a little and kind of see where we stand today. Obviously, we stand at an unprecedented crossroad where on the one hand you have this technological advancement, and on the other hand you have our constitutional principles which have now been built over a period of time, over the period of the last 60 to 70 years. And the reason why I say that we have to zone out a little and try and understand how we must structure all of this is ultimately our laws will have to be guided by our constitution. And although our constitution was drafted at a time when the drafters might have had very little idea of the kind of advancements that were to come in the years, subsequent to the constitution coming into force, it remains what the Supreme Court, for example, has time and again described as a living document. So in order for us to give it meaning, in order for us to try and ensure that its vision is accomplished, we must go back to those roots and try and understand what we are trying to achieve as a society. Because property rights, for example, today no longer occupy a position in the part on fundamental rights. It's been consigned to Article 300A. There have of course been recent judgments which have linked it with the larger right to equality under Article 14. But ultimately, what we are trying to achieve through the Constitution is a set of goals that will treat every Indian as an equal citizen, that will strive to ensure justice not just for one group of society but for justice for everyone. So when we are looking to create a framework for artificial intelligence in terms of how it deals with property rights, I think we need to go back to those roots a little. And obviously these roots are also kind of connected with very many different kinds of philosophical overviews on how society must be structured. I mean, you can have the Kantian perspective in terms, which would argue that something like an artificial intelligence bot could never have moral agency. So it could never be construed as a legal person, whether we like it or not. And otherwise you have, say, Locke's property theory, which would grant individuals property rights so long as they apply resources and apply their own labor to develop something. Or you could look at, say, for example, John Rawls's theory on justice, which is justice as fairness, where you're looking at something called an original position. Now, what is this original position, for example, that Rawls spoke about? Assume each of you was asked today to create a hypothetical society. What kind of society would you look to create? And you must try and answer this question without knowing where you will in fact end up in the society that you end up creating. So if this is Rawls's original position, and if you apply this original position to AI, you might want to try and see then whether at all you want to vest property rights which are connected to what an artificial intelligent agent might develop, or whether we should eschew that altogether and ensure that legal agency lies entirely with human beings. But in that process, of course, there are a lot many other questions that will crop up and which we'll surely be addressing over the course of the panel in terms of how we attach liability to something which an artificial intelligent agent might do. But presently, as it stands at any rate, in terms of laws that deal with property rights that emanate out of artificial intelligence, there are none. Because the present Copyright Act, the way it is structured, doesn't necessarily grant intellectual property rights in favor of artificial agents. And it's something that the lawmakers will seriously have to grapple with. This is not so much as the law being behind the curve. I think we often find that technological advancements are well ahead of where the law is, but in this case, I think the law needs to quickly catch up. Otherwise, it's going to be left by the wayside, and we're going to have like moral chaos, really.
Suhrith, you mentioned when you were explaining the different approaches to property rights, you made the comment around we don't even know whether an artificial intelligence can be considered a person in the legal sense, and that takes me to another broad topic that we wanted to discuss, which is around agency and liability, as you said. So I wanted to ask the panel about two kinds of agents. One kind of agent being, Srinath spoke about agentic AI, and that is the hot topic now. It looks like we started off with ChatGPT's ability to create things, and then we went to ChatGPT's ability to reason things, and then now we are on let's have agents to do things, and let's have my agent talk to his agent kind of situation, right? So we're talking about, on one hand, that kind of agentic power structure, and the other kind of agent that I would like us to talk about is also, it was interesting from the morning's panel around morning sessions around the number of pending cases, whether that should be a performance criteria for something, and so on. And if we were to assume that an AI can be an agent of justice in terms of being law officials. Justice Chandrachud mentioned one of the deficiencies in the system is they don't have an investigative unit of their own now. Could that be an AI investigative unit? And what are the kind of powers it would have, and how would you treat its findings and submissions? And so on. So, Suhrith, I'm happy for you to lead, and then...
Sure, I'll just address this at three different levels. At the first place, at the level of AI as an agent in contracts, for example. Under Indian contract law, obviously, contracts are essentially agreements that are enforceable by law. You need an offer, you need an acceptance for something to result in a contract, in a binding contract. But let's say you have something like an automated acceptance by AI of a contract. Would that then constitute a valid and binding contract or not? Now, you might think that the law doesn't necessarily have answers to this, but I think the question of informed choice, the question of the various things that are contained in the Indian Contract Act are probably enough to answer a question of this sort, just that we haven't reached a sort of situation where we have case law, at least these are still sort of questions that remain untested, as you say. But I think there's a lot of work to be done, certainly in this area. The other is the question of civil and criminal liability. I mean, you could have automated cars, for example, which leads to an accident on road, which then is the owner of the car the person who would be responsible? Or is it the person who has made the car? I mean, because ultimately, especially in the case of an automated car, the accident itself might have nothing to do with the owner's errors or owner's mistakes, or even the driver's mistakes in any manner. So where will liability have to be fixed in such a case? Again, questions that will require answers. I mean, in tort law, you have a conception of strict liability where there really is no defense to the defendant. If an event occurs, then that results directly in liability being fixed and in damages being awarded. So maybe this might be a case for fixing of strict liability on the makers of an artificial machine. But thirdly, and most importantly, I think the question of algorithmic biases, and this is to answer your question on the sort of questions that have propped up from previous sessions in terms of how do you judge, let's say, even judges or the courts and how they act. The difficulty in using AI for something like this, and we've seen this in various different fields, right, where AI throws up not just hallucinatory results, which is a problem of its own, but it also has a number of inherent biases. And it could be bias on the basis of race, on the basis of gender, in the Indian context, on the basis of caste, and very many, and on the basis of a person's social class, on the basis of a wealth that a person has, and so forth. So we've had, I think, problems aplenty with using AI for purposes such as this, and I think we have to be very careful before we jump into using AI for things of this sort.
I'm going to touch upon two things because we are tight on time. Sometime 2 years ago, there was in the Kawasaki plant in Japan, there was a part of the factory where a robotic arm had to press plates against against a kind of a forge. And there was this gentleman, I forgot his name. The the AI operated bot did not recognize him as a human, it saw him as a barrier or a metal sheet. And obviously it squashed him against the forge and he died instantly. Now, to answer the point which Suhrith made, the Japanese authorities attempted to resolve that. I use the word attempted because it wasn't tested in court. Attempt to resolve it by saying who had the last opportunity to stop. So when you're thinking now of autonomous AI or semi-autonomous AI, it no longer is the person who sets it in motion, because there is now there's a gap in the causal link between the prime mover and the eventual effect. Therefore, what the Japanese authorities did is they said, we are going to apply a test of who had the last chance to prevent the bad thing from happening. And so that was one interesting. They said last opportunity. The other thing which I want to pick up on what you said is, can AI be used in judging? They tried this in Korea. This was last year. And Korea, they tried to do an AI-driven arbitration. And of course, people fed in the documents and you instantly got a verdict, which is amazing. I mean, when we hear about years and years of litigation and someone says you upload the documents and you download the verdict, it sounds like magic. But the Korean courts held that such an arbitral award is against Korean policy. Why? Because they said that, and they used a concept called the black box concept. The black box concept is that the way AI operates, the way the proto-neural patterns which are used by the AI algorithm for the purpose of its decision making, there is a gap where we don't know why the AI makes a particular choice in a particular scenario. So that's called the black box. So they said when there's a black box and it's an automaton doing it, it's against policy, which is exactly what Chief Justice Chandrachud told you all, saying somehow I feel happier if a human does it. And that's why. So for example, if I decide to exceed my time limit while talking, he'll accept it because I'm a human. But if a computer is going to keep talking excessively, he's going to go switch it off. So we are all intuitively wired to accept certain failings in a human which we will not accept from an automaton. And so I think that from the point of view of adjudication, I think we will never accept AI, except in some specialized scenarios. But I think there's a huge role they can play in expediting judicial disposal by weeding out cases which are long dead and which have been adjourned for 7 years in a row, for identifying cases where people are dead and picking up from the local records and linking it to the judicial records. So I think there's so much which can be done. Chief Justice Chandrachud did a lot during his time. There's a lot more to be done.
Thank you. One of the things I noticed when we started the session and when we started talking was we assume a certain level of technological competence, and much more than technological competence, technology access and availability here. But we shouldn't forget the fairly significant chunks of population that do not have access to technology and therefore left out of some of these benefits that technology can bring in. And I'd also think that those are also the sections of population that actually need much more of these results in terms of the expedited result than all of us would, for example. And much more than people being poor and not having access versus not having access at all by design is a whole different game. And this is where I'd like Professor Rabbiraj to chime in and talk about the role of technology, the role of access or not access to technology on the one hand, and also when large populations migrate, where we have a situation of a humanitarian crisis, if the intake processing is an AI processing, for example, what would be the kind of impact that would have? Because here this is a double whammy. On one hand, you don't have your phone, you're stuck somewhere You don't have access to the internet, you don't have access to your custom GPT or whatever. And on the other side is a system that completely relies on technology and is seeking more information that you probably don't have at hand. So, Professor, please.
Thank you very much. It's a very interesting topic which we have been discussing. I just wanted to add one point to the previous discussion. There are three things that I wanted to touch upon. One, primarily, as my learned speakers were touching upon the jurisprudence of property. The fundamental question here is that it is widely accepted property ownership can fall squarely only with a living person. Now, having said that, you see the existing jurisprudence. You may take the fictional theory or the organ theory, which says that like the status that we have granted to a company or an entity, we can squarely give it to an artificial person. Now, the thing that disturbs me here is, what is the advantage if we, for the sake of acceptance, accept an artificial person to have the status of a real person? Now we see the property disputes are phenomenally increasing in our country. Mitigating that itself is a challenge. Now when you, for the sake of acceptance, that if you give the jurisprudential development that is happening, where scientists are now saying there is a scope for AI to have digital conscience. They say that AI can learn by itself. That's what my fellow speaker also was trying to address. Now, given that scenario, what would be the legal repercussions? Point number one. Secondly, when we discuss about the contract existing law, about who is an agent, the contract law specifically says that agent has to be a person, not based on the nature of the work, but legally speaking, it has to be a person. And what if you allow AI to delegate the job to somebody else? There comes the question of liability. Now, in the natural courts, when we see either it is a master-servant relationship or we attribute strict liability to a dispute, imagine if that has been allowed, who will take the liability? Whether the person who designed the program, or the one who has trained the program, or the person who has purchased the program as a product, or will you apply product liability? So these are the two things I wanted to add up. The third thing that you have asked to me here is about the humanitarian crisis and the role of AI. Now I'm seeing it from, as a student of international law, I'm seeing it differently. I'm seeing that the subject of AI has to be seen from two dimensions. One, the progress that is happening during the peacetime and the progress that is happening during the wartime. So in the peacetime, we are seeing that scientific advancement in AI is actually creating a lot of interest in us. But at the same time, I fear with this interest, we have a responsibility. The responsibility to see that the AIs are programmed, structured, trained like a parent and a child, and the child is at a later point of time led to do things whatever the child wants. Now the question here is that in peacetime, when we program AIs, the major challenge before us here is that whether the product as an AI or a robot, is it going to really consider the human sentiments, human emotions, and is it going to be fully human rights compliant? Which means if the person has to interact with me, or if the person is really in a need to assist a person, like my fellow speaker was saying, that you programmed a robot and without knowing it accidentally hit you. Even in humanitarian crisis, the problem here is that when you design a program and you label it and make it as a product, who is going to take the ownership, first thing. And second thing, how compliant, human rights compliant are our existing artificial intelligence in a common sense. And being specific, the plus side of it is that in humanitarian crisis, to a larger extent, we see that artificial intelligence to a larger extent has been helping, but it is being supervised by human beings. So you can't make it autonomous fully, but if you can have a person behind it who is trained to handle machines, then letting machines handle human beings. In humanitarian crisis, we see the challenges are still before us, but at the time being, we see we can use artificial intelligence, not fully autonomous, but with the support of human intervention.
Thank you so much. We have our half an hour is pretty much up, so before we throw open to questions, I just wanted to summarize a few things. One is very clearly we need more work in the area of structuring or refactoring, to use a programmer's term, some of our basic laws, especially around property, agency, liability, and so on. There is space for that. The second is, as Professor said, I think he kind of reinforces the need for what at the Hindu we call the HITLO approach. That's HITLO stands for human in the loop. And we also use what is called a sandwich HITLO, which means we want the action to be initiated by a human being. The AI does something, gives the output, and then a human being then has oversight over it and then approves it for publishing and whatnot. So, two major takeaways. I know that I said we'll talk a little bit about what else do lawyers need to learn. I'll leave that for the questions.
Very good afternoon to all the members on the dais. First question, the question which I want to ask was already in the discussion, but it was related to AI and the liability, related to self-driven cars, on whom the liability will be going. And majority of the arguments in that is it's rely upon the creator as of now. And at the same time, when we talk about in the terms of intellectual property and where that copyright protection should be given to whether it should be given to creator, whether it should be given to the one who is giving the prompt, or the AI itself. At the previous instance, when we are talking about the liability should be kept on the creator, and this side, the whole argument is totally against, where they are saying the creator should not be given copyright protection because he has not added any sort of labor or work in creation of that particular output related to the novel work which will be coming out from the AI. So the question is, at one time when we are giving and making the creator of the AI as a liable for the act, at the same time, why not we are extending the benefits also what the creator is deriving from that? So that is the question.
Yeah.
That's a great question. That's precisely why I segregated civil and criminal. Let me answer your question in three parts. First, the car example. There was a case on what you're saying in the US, I think it was in 2022, where a Chevrolet car, it swerved into an autonomous car, swerved into the path of someone else to avoid some other vehicle. And this gentleman, he got so startled that a car is coming into his lane that he swerved and got injured. Unfortunately, that was settled by Chevrolet, and they also agreed to put up a disclaimer for the future cars. So no principle of law was laid down, although the company, the manufacturer, did in fact accept liability. Now, the reason, in my view, and I'm going to wait to hear what Suhrith also says, the reason there's a difference between civil and criminal is this. When we talk about vesting rights in a form of art or a song or a painting, it enables a citizen who has used a machine to claim rights against the whole world. Okay? Whereas in the case of criminal liability, let's take the Chevrolet case for example, you are trying to get reparation for a person from the wrongful acts of an automaton created by someone else. Now, this was very early AI days. It's very interesting to see how this will evolve when the AI becomes autonomous or semi-autonomous, can you still then hold the manufacturer liable? I don't know. I would say no, but I wait to hear what Professor and Mr. Parthasarathy say.
Yeah, I mean, I think your broad question seems to be on the jurisprudential disparity, so to speak, in the sense, on the one hand, you're saying that an AI cannot own, or the maker of an AI cannot own, say, a copyright over the AI's creation. But on the other hand, you want to vest liability on that same person for a product that they've created. Look, I think we might want to try and answer this question. In answering this question, also look at other kinds of examples, not just self-driven cars. Let's take, say, medical diagnosis. And let's say a hospital uses AI to diagnose its patients, and the diagnosis turns out to be incorrect for some reason. In such a scenario, perhaps you're not vesting liability with the maker of the AI. I mean, some person has a human agent, in this case, let's say a doctor or some other professional, has chosen to use artificial intelligence to make the diagnosis. So perhaps in such a case, the kind of liability that you're foisting might be different. But the reason why this may be different in the case of self-driven cars is if, let's say, the state allows people to buy self-driven cars and doesn't necessarily say that you're buying this at your own risk or some such, underlying caveat, then perhaps it's for no fault of theirs that this accident has occurred. So I think there are a number of different nuances to this which will probably only really crop up in time. So we'll have to look at it in terms of different kinds of cases, in terms of because negligence itself as a concept in tort law, it would require you to have a clear chain of causation, right, of something leading to a harm. So unless you can show that causation of harm, then liability gets broken or liability doesn't vest. So ultimately, if that chain can be built up and can be shown and it's an inextricable chain, then liability will vest with that person.
So when we talk about liability, to the question that you have asked, I would slightly differ, because when a product has been launched and when a company, either it's buying it or producing it on its own, it is creating a promise, or it is telling to the customers that my product is best. So there is an implied contract between the buyer and the seller. So now when it is to car, I'm speaking in terms of a customer, not in terms of a owner. So I'm buying this car with a faith that this is a car that's going to help me. And if an accident happens, who shall be responsible? When you are selling the car to me, saying that it is fully complied. So then the question of argument for a rebuttal, I'm just saying, it would be that the company has to compensate me, because the company is in a dominant position. And only if you make at some times the company responsible, then the R&D development as well as the ethical compliance team will ensure that this particular damage or the causation of an accident that is likely to happen could be reduced. So I feel that the liability principle with respect to use of artificial intelligence must primarily lie with a person who is in a dominant position. For this example, we can say it to be a company. For other examples, we will have to articulate it. But if it is a company which has a dominant position, I feel they have to take the responsibility because they have a higher degree of responsibility. Thank you.
We have time for one more question. Yeah.
So actually, I wanted to ask 3 questions, but since we don't have time. So I think Mr. Sridevan sir actually touched upon a decolonial perspective to the entire notion of property by talking about how the notion of property began as a Western notion by itself. So I think the concept is there inherent within regulations as well, because today when we talk about regulation of artificial intelligence, we look to the EU or to California, right, to the United States. I think scholarship has called this the Brussels effect or the California effect, where the regulatory wind is flowing from those countries to, colonized countries, right? So I just want to know, how should India adopt a regulatory regime that is suitable to its own infrastructure rather than looking abroad?
Okay, I love this question. I wrote an article in the Hindu on the need to look eastwards. Exactly what you said. Completely agree with you. So I'm completely biased in your favor. Uh, so I don't think we should adopt the Western approach. The Western approach is something called the risk pyramid effect, risk pyramid principle. I believe we should follow the Chinese and Japanese model, which is ethos based. So they weave the cultural values into the algorithms. Yeah, so it's all there in my Hindu article. So subscribe to the Hindu and check the archives for my article.
Absolutely. Thank you very much. You've been a fabulous panel. I found. Oh,
Yeah, good afternoon. As you're aware, like there's an ongoing case with regard to AI-generated work, which is in the Delhi High Court, which is OpenAI versus ANI Media. I would like to know your takes on the aspect of the AI-generated work.
I think it'll take quite a while to answer this in.
maybe Suhrith can write an article for the Hindu on that topic. And on that note, thank you so much. You've been a fabulous panel. Yeah.
Look up Thaler, Thaler versus Perlmutter, Perlmutter. Okay, that will convey my views broadly.
Thank you so much. I have to say that I learned a lot this past half an hour plus 10 minutes. The questions were super interesting. I'm happy that most of what you all asked was also covered in our panel. So thank you so much. Thank you again.